And also, I wanted to ask you before we run out of time for this first half, are there certain techniques that people have used that can be problematic when they are thinking about the financial planning?
Oh, absolutely. There are situations where people will put a child, for example, on an account, a joint account.
And that's a common thing. We always hear, when you're talking, people talk about that. Should I put my child's name on? Should I put on an account, on my home? What do you think of those two?
I think they're no-nos.
Oh, okay.
In non-legalese. There are so many issues that can come up when people do that. And there's a lot of people who, we call it amateur planning, will look to do those for a variety of reasons. For example, I commonly hear from clients, well, I put my son on my house because I didn't want to have to worry about inheritance taxes, for example.
Yeah, exactly. I hear those things as well. So you're saying no, not to do it.
Yes.
So it's good to give people an actual answer that they should avoid.
Yes, and I can certainly share a couple of reasons why at this point.
Yes.
Because, first of all, in Maryland, there are no inheritance taxes, so that's not a reason to do it. Avoiding probate. There are other things that we can do to avoid probate, because the downside of putting your child on an account or on a house with you is that in the event that you need to go into a nursing home, there is now, we're almost at a 5 years, and you might have heard of this, and probably a lot of people have heard, it used to be a 3-year look back, now there's a 5-year look back. So any transfers to children who are not living in the household, etc., or there are some exceptions where one might be able to do it, and I can, if we have time, go into that. But that transfer of the house or putting that child on the deed with mom or mom and dad now creates an eligible period of time for Medicaid. If they had not put the child's name on the deed for the house, for example, that would not occur.
So they would not receive Medicaid services for a certain duration of time.
That's right.
That full 5 years?
No.
No, it's the 5 years back within the time, and then for a certain duration they wouldn't receive services. Okay.
The state. Go ahead. I'm sorry.
I was just going to say that's a very important point.
Yes.
Yeah. Go ahead.
Yes.
Finish your thought.
And they determine what that period of ineligibility will be based upon a state figure of $6,800 at present. It's always changing, however. The $6,800 is supposed to reflect the average cost of nursing home care in the state of Maryland. So, for example, mom and dad put their son Joe's name on a deed. Now dad's going into the nursing home. But now the son is a joint owner, so they've transferred ownership within this 5 years. They did this 2 years ago.
Okay.
So what would happen is the state would say, okay, that was valued at $100,000. The house was valued at $100,000.
Right.
They take the divisor, which is the average cost of nursing home care, $6,800, and they divide that into the value of the transfer.
Okay.
And that's how many months that mom and dad will have to pay privately for that nursing home.
Gosh. So there really is a penalty for doing that. We're going to come back after a minute and go into more of the things that you as an elder law attorney can help us with.
Okay.
We'll return after this short public service announcement.
So, do you have any questions?
What is your soup of the day?
We have a mulligatawny soup.
Oh, do you have any specials?
We have a steak special today.
Oh, how's that cooked?
That's pan-seared and then...
Does it come with a side dish?
Is it grilled? Can I have it steamed?
So, what do you recommend?
What kind of pie do you have?
You're an actor. Aren't you from Ohio?
Any questions?
Ask questions. For the 10 questions everyone should know, go to ahrq.gov.
Welcome back to It's a Woman's World. We're speaking with elder law attorney Mindy Felinton. Hi, Mindy. We were talking about transferring the name of a child to a parent's account and also a name from a house. Should we add a child to our house or not? So I'd like to kind of review that a bit, because that was really important, and your answer surprised me. And also I want to go into, is it illegal to transfer assets within 5 years of going to a nursing home? So it's this transfer question.
Okay, sure. I definitely do not recommend that people put their children on accounts, which commonly happens because they think that it's going to avoid probate, it's going to give the child the ability to handle things for the parent, but there's so many downsides to doing that. And it's not limited to just Medicaid planning, for example. It's putting the parent at risk, because what happens is if my son John is on my account with me and my son John is in a car accident, that joint account then becomes subject to being attached by that person who he hit in a car accident if he does not have sufficient insurance, for example. Or if my son gets divorced and my son's spouse is able to attach joint accounts, again, that account then becomes something that's subject to being taken by the ex-spouse.
So in other words, that does something that qualifies your account to an extent where it harms it.
Right, it's at risk. You've worked hard for that money. You need that money as a parent to be able to live out your life, and you could definitely put yourself at risk by putting a child on an account with you. And a lot of people think that, well, we do it because it's convenient. So if you're choosing, say, your son John because you trust him to be on a joint account, then what I suggest that you do, because, and I'll backtrack for a moment, when you do that, you've limited John to that bank account. John does not have the ability to also have authority over your house, your stock account, your insurance, and various other types of accounts.
Meaning to help you in case something happens to you and you need help.
Right.
To the parent.
Right. And so if you trust your son or your daughter or whomever to put them on the account, then I would suggest that you give them what's called a durable power of attorney, which will give them the ability to handle all of those different types of accounts.
Okay, well that's a good distinction there, and important information for people to know. Good, thank you.
And then it does not jeopardize that joint account,
right?
Because the child's not on the account as an owner.
Okay, and then let's go on to the illegality of transferring funds within 5 years. How does that affect?
Well, that's one of the most common misconceptions that people have when I hear conversations, people talking about, oh, you know, Medicaid, et cetera. Well, you can't transfer money within 5 years. It's illegal. It is not illegal. And I hate to use a gender-specific example, but it's an example that is so readily understandable. In the field hockey, or in ice hockey, there's a puck. The goal is to move the puck down the field, down the ice rink.
Okay.
And sometimes they use sticks illegally, or not illegally, but against the rules. The players will hit each other, and they end up in the penalty box. They get a penalty. That's what happens in transfers within 5 years. It's not illegal, but a penalty gets imposed. So nobody's knocking at your door that they're going to arrest you, but it's a civil penalty, and that's really going back to the calculation of the $6,800 per month that gets divided into the amount that was transferred within the last 5 years. So people can get qualified for nursing home care even if mom's already in the nursing home and they've made a transfer within 5 years. There are different strategies that elder law attorneys can use to remedy those transfers.
Oh, I see. So you're saying it's worth it to take the penalty at times in order to keep the rest of the property or the money or whatever it is that you need.
Absolutely.
Okay.
That's
I
exactly
guess that's
right.
probably how it got started. There's a penalty, so people thought, oh, you cannot do it, so that it could be illegal, but it's not illegal. There is a penalty, but at times it's worth it to accept the penalty for a greater gain of what you need to live, really.
Exactly.
I see. Very interesting. I hadn't known that either. Okay, another piece of information that people always get confused about, and I know I do, is can you tell us the differences between a living will, a living trust, and then a will, regular will?
Sure, sure. And that goes really back to more of an estate planning type of practice, which we do as well, because part of